Hi friends from around the world, let's go copyright again. This is about the intersection, the interesting intersection between copyright and competition law. You will not have this a lot, so I think from the business perspective that is quite interesting. I will explain it on the basis of a judgment from the European Court of Justice. So we'll do it. This is the business channel here. I will do it on the angle of the organizer of a music festival, or of a cafeteria, or a restaurant, or a casino, whatever business you might have, and where music and collective management organization play a role. So this is judgment from the European Court of Justice from November 2020. It's called SABAM. SABAM is a collective management organization in Belgium. It is monopolistically organized, so it is the only organization of collective management of copyrights and related rights in Belgium. And they collect fees for the authors of musical rights, of copyright owners, from, for example, and in that case, from festival organizers. Festival organizers, so Belgian festival organizers who did some work in some festivals in Belgium and then were subject to pay the royalties, so to say, to SABAM. So this is the background, and SABAM has two kind of fees they can choose from. One is a basic fee, which is, so to say, calculated on the revenue which were produced by the festival organizers, or a minimal tariff which would be calculated on the basis of the total seats available. This is the background of SABAM, and why is that with regard to the European Court of Justice? Well, again, I will tell you there's a directive in the middle, and the directive is a European law which has to be transposed into national law, in this case Belgium, which has been done. And the directive I'm talking here about is the directive of collective management and of copyright and related rights. So that is, so to say, the background of the case. This time, Belgium. Why not? Now, the Article 16 of the directive, here it comes, says that the economic value of the provision of the service of the music, so to say, which has been provided or is covered by the collective management organization, has to be translated into the royalties which are being collected through the organizer, in that cases of the festival. That makes sense, right? It is, so to say, a free market approach where you want to give a value to somebody and receive a fair value in return. So that's what it is, and so to say, what it should be, right? I would encourage you to look at your home jurisdiction, where you surely have collective management organizations, but how are they organized, and how is their tariff being calculated with regard to the economic value, or with regard to whatever the parameters are? This is something you have to look at. So I'm looking here at the European jurisdiction, obviously, and that is what the channel is all about. So I give you a glimpse of what is European law, and you then look at your own jurisdiction, and you may find an argument in this way and in that way in order to improve your legislation or your case law, or you may help some arguments, may draw some arguments out of here in order to help your client in your home jurisdiction. Now, what happened here? It happened that the referring court, so the court which in Belgium has been seized by SABAM, they had to judge whether that was the basic tariff here, so on the revenue, on the part of revenue, one part of the revenue, of if this was the correct way in order to calculate the royalties of the SABAM. Well, the basic tariff is a percentage, and there was a reduction. Even there was a reduction, I didn't mention it. The reduction is a possibility if only of the music repertoire which has been played, only 1/3 of that music is being covered by SABAM author rights, so to say, then there would be a reduction of 2/3. And on the other way around, if a minimum of 2/3, or if you between 1/3 and 2/3, then there's a reduction of 1/3. So there's a reduction scheme. Now, what was the argument of the festival organizers? Well, they say, the revenue is one thing, but on the revenue we have a lot of deductible costs, so to say. We make a high value event, an experience which is important for the people, which cost money. So that has to be deducted by SABAM in order to get to the value of what is only the music, so to say. That was their main argument. And the court has some doubts on the Belgian law in the light how it has been transposed by the directive. So at the end it has some implication on the European law, and therefore the European Court of Justice, through Article 267 of the Treaty of the European Union, could be seized to interpret what is the economic value be meant in Article 16 of the said directive. Now, what was the reasoning of the Court of Justice? Well, they said that, and one of the findings, well, it confirmed a previous decision that to collective management organizations, and more so in the case of Belgium, where we have only one monopolistic collective management organization, which is SABAM, the competition law applies. So, and that is the first thing I want to make clear. We have a copyright and we have a possibility for the national authority to determine 1, 2, or 3 of kind of monopolistic management organizations, collective management organizations, so that must obey to certain rules. They cannot do whatever they want to do. They have to do it fair, non-discriminatory, etc., etc., and also in a way which is not abuse of its dominant position. That comes now from the angle of competition, and that is what you as a restaurant owner or a festival casino owner, proprietor, that what you have to take in mind, to have in mind when they come with you with a payment fee of whatever it is the National Collective Management Organization wants from you to pay. So the competition law is applicable, and there is so the notion of non-abuse of the dominant position, right? Now, what is it? The fair economic value, or the economic value, must have a relation to the economic value of the music provided by the CMO with its author's rights. And here we have the possibility to do different methods of calculation, and that method which has been chosen by SABAM was as such not criticized by the European Court of Justice, because they said, well, that is the normal way, that is the current way, which is the response to the market on how to calculate these fees. So that is not subject to something which is in SABAM only, but which is the normal way to calculate, either focusing on the seats available or focusing on the revenue generated. Now, so that cannot be criticized as such. Now, the economic value as such, so the method of calculation is one thing, but the actual calculation of the fee, whether this is or not a fair value, that has to be done by the national court. So that is not something which is to be, that is on factual circumstances, right? That cannot be, that is not a question of law which the European Union Court of Justice can decide upon. But if there was a clear mention that the 1/3 and 2/3 rule may not be the best one in order to calculate the economic value, because there may be a calculation which is more precise. And well, you have the 1/3 reduction or 2/3 reduction depending on how much the author's works have been used in the festival, but it is very rough rule, right? So if you have 50%, you would still get only a 1/3 reduction. So there would be in that case an overpay by the part of the organizers. And in that case here, precisely, it was required by SABAM that beforehand they get a clear overview over the pieces of music which are being played, which enables on the other side SABAM, in order to make a concrete calculation, how much percentage would represent their own music, so to say. So an alternative calculation was possible here, and this is the thing for what reason it has to be resent to the national court in order to, they get the parameters and they make the decision afterwards. Now, what is the overall, so to say, morale from that case? Well, there are two. The first is the competition law. We have the competition law applicable to kind of monopolistic approach. They are subject to competition law, and that is so. Intellectual property is not an isolation. There may be go to the intersection of competition law, and that is one of the issue I wanted to point out. And another consequence of the court judgment would be that next time you get an invoice from such a collective management organization in Europe, right, in Europe, you would think of alternative methods possible, which approaches more to the economic value of the services provided. So it is, and there may be other, so I talked about these two, about the basic and the minimum tariff, but there may be other alternative calculations which are possible, and which then, without too much bureaucratic burden for the collective management organization, it should be applied in order to make a fair value of the royalties payment. So that is, it has to do with copyright, it has to do with competition, and it has to do with small businesses, because you may get, as a casino owner, cafeteria, restaurant, you may get in that situation. And I wanted to give you here the perspective in Europe, and you might use this perspective in order to, well, hopefully to make better what is in your home jurisdiction. Thanks for joining me today.